Act show for today is the Hunwardsen matter. So if you are here on another case and you think you have a hearing, we are not aware of it. So please just type something in the chat letting us know. It doesn't look like, it looks like everyone for Hunwardsen, but if somebody thinks you're here on another case, please give us a heads up so you're not wasting your time thinking that you're having something to be heard today. Thank you.
Started.
Real Water's ready to proceed, Your Honor.
Terrible Herbst is ready to proceed.
So the plaintiff, Sean.
Okay. Okay, so welcome back. This is case 831543, which today's purposes is pages 1 through 36. And counsels, I wasn't going to have you do appearances again unless you want to, because we have the same person helping us as a court recorder today, so they have as the other day. So does anyone really want to do an appearances, or anyone need to introduce somebody who hasn't previously made an appearance? I'm seeing negatory nods from people, so okay. So before we get started, in the never-ending, Mr. Pepperman, this might be a you question. As you may have realized, the stipulation with regards to the liability and causation did not have anything on it that set forth that Terrible Herbst had seen the version that was actually submitted to the court, and so the court couldn't sign that. Is there some remedy that maybe you all want to do here in open court, or something that you're going to do? What's the thoughts? And then we'll ask Counsel for Terrible Herbst.
Your Honor, after we left, I understood that the court expressed that concern yesterday afternoon. We submitted by email the final copy of the stip to Counsel for Terrible Herbst, asked them to respond whether they approved as to form and content. Ms. Rojas responded to the email confirming receipt. They do not approve, but they have reviewed it. We are attaching that email confirmation to the stipulation. If it hasn't already been resubmitted, it'll be resubmitted shortly.
Okay, does that meet the needs of Terrible Herbst?
Yes, Your Honor, I did get that last night.
Okay.
Confirmed that was the final version this morning.
Okay, so then, in light of that, what I'm going to do based on your statements, you can appreciate you're going to get a return for yesterday's one since you're going to resubmit it, so we just don't clog it up with two alternative versions.
Yes, Your Honor, that's fine. Thank you.
Okay, so just going to give it that. Okay. Any other administrative housekeeping matters for this morning before we get to your substantive motions? No? Okay. The court is going to mention actually one which we do not need to deal with today, but please put it on your list, and I appreciate that there's pending motions that might impact this. But before we get to the calendar call, can we make sure that we have a correct caption, please? Right? So that you, for any purposes that people may need it for purposes of trial, and any clarifications, whatever, just so we get a nice correct caption of who's actually still in the case. Is there any reason we couldn't do that by calendar call? I don't know if you all have pending different things that might have different deadlines.
I think we're going to try to do it right away because sometimes it takes a while to filter through the clerk's office. Then the jury comes up and they see settled defendants on there and it causes a potential problem.
Hence,
we'll try to get it done right away.
Hence why you understand that the court asked it to be done by calendar call, realizing that sometimes things don't. They don't let me do, you know what I mean? There's certain things outside our control, just realistically it makes it easier for people so you all don't have a screenshot down there that has a whole bunch of different parties.
Right, yeah. Given it's Christmas time, it's probably better to get ahead of the curve.
Okay, so earlier is always fine, just want to at least by calendar call realizing that there's still substantive motions. Okay, I'm going to address your other OST later on today. Let's get through some matters, okay? And then we'll figure out a way to get that taken care of. Okay, so what we have on for today is, first we said we were going to be doing document 663, plaintiff's motion limine number 11 to pre-instruct the jury on standard product liability instructions, document from Real Water 813 opposition, document 839 ET&T's opposition, and document 930 plaintiff's reply. I think it's going to make the most sense just to let you all do oral argument on this rather than give any inclination because there's a lot of different moving parts. Go ahead, please.
Thank you, Your Honor. I see this motion conceptually as having two separate issues. The first is whether any pre-instructions should be given by the court? And second, if so, what those instructions should be? So addressing the first part, whether pre-instruction should be given, I think that as we lay out in the brief, it's certainly a matter of the trial court's discretion on whether to give pre-instructions. It's not an uncommon practice. Some judges are open to pre-instructions. Some judges don't always give pre-instructions. It's not a controversial practice, so there's not a lot of case law one way or the other on it. We've cited a couple cases where it's been approved. The defendants haven't cited any case where pre-instructions has been ruled as, the concept of pre-instructions have been ruled prejudicial or wrong or error or an abuse of discretion. So the studies that we cite in the briefing, I think overwhelmingly support and reflect the benefits of pre-instructions. The studies, largely in uniform, have found that pre-instructions reduce bias amongst the jury. It assists the jurors with recall of the evidence. It improves juror satisfaction with the process. It facilitates the integration of law and facts and helps jurors defer judgment about a case until after the proof is presented. And I think conceptually this makes sense. It gives jurors who are unfamiliar with this process a basic framework to help understand the proceedings and what's about to lay out in front of them in the trial. This is particularly beneficial in a strict product liability case, which is not a concept that jurors will be familiar with, and it's a novel concept in the law. So giving pre-instructions on the basic underpinnings of this strict liability concept is really beneficial to both parties. It just helps the jury be engaged and understand the evidence that they're going to hear from both parties. So given the benefits in general and the fact that, we're not looking to do anything that's unfair to anyone, we just want to give the jury some pre-instructions as a framework to the trial, which we think was beneficial to both parties. So we would respectfully ask the court to allow some pre-instructions on the substantive claims in the case. If allowed, what should those pre-instructions be? They should be limited pre-instructions on basic issues, not every aspect of the trial. I don't think that's what the request is, and there's no argument that that's the case. Things like the elements of strict liability claims that we're asserting, basic definitions, standards, and concepts that are largely the standard jury instructions that are given in a product liability case based on the law in general. Nothing specific, nothing that argues the plaintiff's case or defendant's case. I think the full set of jury instructions obviously is given at the close of trial, but some basic pre-instructions on the standards, concepts, definitions, elements that are outlined in our motion, I think is appropriate. In terms of an exact definition of what those instructions will ultimately be, that may change based on the court's rulings on motions that are still before it. But in terms of an order indicating if the parties are allowed to give pre-instructions and any issues with the pre-instructions that are proposed, assuming that the court's orders don't change those, we'd ask that those pre-instructions be given.
Okay, I do have a question because it's raised in both of the oppositions, right? That taken a little bit differently depending on which opposition, but that many of the quote proposed jury instructions are not straight pattern standard instructions. They have modifications by plaintiffs. So do you want to spend a moment to address how the specific requests, not the global concept, right, of jury instruction, pre-instruction, but how these specific requests that you're saying would be appropriate when they're not the standard patterns, or maybe you say they are, and how a court can pre-do that when all parties would not have had an opportunity to acquiesce to those modifications and to know if it's consistent with applicable law as presented in this case based on the facts in this case.
Well, I'm not sure that
If you look at Real Waters, they say basically none, and then they say if not, alternatively 1 through 5, and they raise the issue of 6 through 11 would give examples of different language changes. In ETTs, right, they start with number 2 and give examples on each one where they say that there are language changes. That's why I was saying it's a little bit different, but they each say that there's language changes, and the language changes matter from their argument. So that's why I'm hearing your general concept on pre-instruction, right? But how does it address what is specifically requested in this case?
Well, I mean, I think there's certain changes to be specific. For example, to say, you know, in the standard instruction that we don't have to prove a defect. That's based on the case law. I don't know that there's any dispute as to the basic law that plaintiffs in a product liability case don't have to prove a specific defect, but hydrazine, you know, it just says you'll hear evidence that hydrazine was in the water. So I don't know that modification is anything that means anything. There's no dispute that that's what the theory is that hydrazine was in the water. It's admitted.
But theory versus actual instruction, right? Isn't that kind of the clarification that's pointed out in the opposition, right? Instructions, right, have a certain imprimatur coming from the court as a jury instruction versus an assertion by a party as to what they intend to prove or what their theories of claims defenses are?
Yes, Your Honor, and it's not our intent to inject any theory into the case. I mean, it's just the fact of the allegation is that hydrazine was in the water. I don't think that that's a controversial statement. So technically it's a...
Counsel, have you been here the last couple of days with some of the arguments by some of the parties in this case? And I'm not saying you agree or disagree with their position, but as far as it being disputed, I believe there's been a whole series of motions. The court would have needed to rule on a whole series of motions if it was undisputed, both over the last few days and coming up today and early next week, right?
I understand.
I'm sorry, I'm kidding a little bit, but
know.
you know what I mean? When you made that statement, I mean, that's kind of...
I should say that it's not controversial that's what the plaintiffs are stating is the hydrazine's in the water. And it's not like we're asking the jury to be instructed that hydrazine was in the water. All that instruction says is you will hear evidence that hydrazine was in the water, but they don't have to prove any specific substance, which is a correct statement of law on that jury instruction. The rest, I mean, the modifications I think are more related to differences between the various pattern jury instructions. There's different versions that have been cited. We have cited I believe it's the 2014 version, but we're not taking a position that it should be this pattern jury instruction or that one, and we're open to meeting in instructions if they're allowed to be given. Like I said, we're not trying to use this to gain some advantage over any of the other parties. We view it as pre-instructions give a framework to the jury that benefits all the parties. And we're not saying it's to the exclusion of any other party's ability to weigh in on what the final language of those pre-instructions should be. We're open to propose modifications. This motion, I think, the problem is they're disputing that any pre-instructions should be given and aren't proposing alternative ones in that scenario. So we haven't been given the benefit of hearing, okay, what are your concerns? I mean, we can probably work through a lot of them because, like I said, Your Honor, our intent isn't to gain some sort of unfair advantage here. It's just to give the jury a framework that we think will be beneficial to all parties.
I appreciate it. Thank you so very much.
Thank you.
Okay, Counsel for Real Water, since you're 813, why don't you go next if you want to? Or...
Thank you, Your Honor. Mark Love is going to make the argument on behalf of Real Water and Affinity.
Okay.
And Your Honor, I'm on video. See me and hear me okay?
Yes, I was looking because you were here yesterday, so I was looking for you today. Okay, yeah, I can hear you. Go ahead, please.
Okay, thank you. Yeah, Honor, just 4 quick points. And our position is pre-instruction on product liability isn't necessary at all, and plaintiffs really haven't shown a reason why that would be necessary. Second point is Real Water stipulating the liability position. There's no need to instruct on liability instructions. Third point, if we are going to pre-instruct, our position is the Nevada pattern instructions 7.123, 7.4 would be appropriate, and all of plaintiffs' additional instructions are just simply not supported by California law, and they've made some alterations that are inconsistent with the law. And as far as their additional instructions regarding adulterated products, our position that those are not supported by any case law.
Okay, appreciate it. As you may have heard yourself, you were starting to cut in and out. So if you're going to be speaking again in final words, you might want to try and see if you need to tweak something. I'm not sure if you need to come closer to the mic, if it's a connection issue, but let's move forward with ETT and we'll circle back then to plaintiff for final word. Go ahead, counsel for ETT. ETT/Terrible Herbst. Which way would you like me to call you?
Terrible Herbst, please, Your Honor.
Okay, we'll call you Terrible Herbst. Okay.
Thank you, Your Honor. I'd like to first start with our general overall objection and then go through each of what I understood to be the remaining proposed instructions given the plaintiff's reply. So first, with respect to our overall objection, we concur with Real Water. I don't think it's necessary to give the jury substantive instructions. And our CP 51D1 specifically states that the court must instruct the jury before the parties' closing arguments. And there are good reasons for that because there is an ever-changing landscape in many cases, as there is here. And it also is, it lends some risk to the use of those instructions as argument during opening and throughout the trial when we haven't heard all the evidence and we haven't all agreed upon what the final instructions should be given that evidence that is admitted. So for that reason, we would object to all of them being given. But in addition to that, as for PL number 1, which I think the plaintiffs still want to give, that seems to be an introductory instruction, which leads to the rest. And so I don't think that's necessary, especially because we're going to object to the following. What I understand to still be at issue is PL number 1, PL 2, PL 7, and adulterated product special instructions number 1 and 2. So I just addressed the introductory instruction, but as to PL 2, it includes language concerning defective manufacturing. And to my understanding, the operative pleading, Your Honor, in this case is the third amended complaint. That's docket number 243. There is no cause of action for defective manufacturing. You may recall this case started out with 9 causes of action and many defendants who are no longer here. My understanding that the remaining causes of action are as follows. First cause of action for strict liability, failure to warn, and that's as to the remaining defendants. Cause of action number 2 is breach of the implied warranty of merchantability. There's a third cause of action for negligence per se, which I understand has been dismissed as to real water, and that might be a housekeeping matter. I know they dismissed or withdrew the claim for negligence, but there's a claim for negligence per se in the third cause of action, and then in the fourth cause of action, a claim for negligence. So,
But negligence per se under Nevada law is a form of negligence. Let's get that one cleaned up, right? Your counsels for plaintiff, were you withdrawing both forms of negligence?
Yes, Your Honor, the negligence-based causes of action are withdrawn.
okay, that's my understanding. So we've got 3 remaining causes of action then. The first 2 I just named, and then the 5th cause of action is strict liability, unreasonably dangerous condition. None of those causes of action relate to manufacturing, and that's the basis for our objection to PL number 2. With respect to PL 5, it is not a standard instruction. They have made substantive changes, which we do not agree with, and we would object to giving that instruction. PL 7 relates to prior incidents. I think we got to some of those issues, but those prior incidents are the subject of a number of motions in limine and probably additional objections at trial if admitted, and so I don't think it's appropriate to pre-instruct on evidence that's in dispute and it has not come into evidence yet. And then as to the final 2, adulterated product number 1 and 2, there's still some dispute as to whether, I believe that's MSJ number 1 that's still pending, Your Honor. We don't agree that this is an adulterated product substantively, and so we would object to those instructions, those special instructions. They're not standard instructions, and there's no basis to give them in this case. And with that, I'll submit.
Counsel for plaintiffs, you get last word. Go ahead, please.
First, addressing Real Water's arguments, that we haven't demonstrated that pre-instructions are necessary. I think we've shown that they provide a framework to the jury and a benefit to all parties. That's not relevant because Real Water stipped to liability. They did not stip to causation for Plaintiff Brody, and Terrible Herbst is still disputing liability in this case. So the pre-instructions are, at least as of today, relevant. Going to Terrible Herbst's argument, the NRCP 51D1, court must instruct the jury at the close of evidence. We don't suggest that the court should not instruct the jury at the close of evidence. All we're asking for is some basic pre-instructions at the outset to, again, give the jury a framework for the presentations by both parties. With respect to the argument that these the pattern jury instructions have been substantively modified, my review of most of those arguments as to substantive modifications are just differences between the various versions of pattern jury instructions. We are open to meeting and conferring on which pattern jury instruction to use on those. I don't know that there's a huge reason to fight over the elements of the claims, the definition of unreasonably dangerous, what constitutes a design defect and a manufacturing defect. The claim is strict liability product defect. Under the law and the pattern jury instructions, product may be defective due to its defective design, due to a defective manufacturer, or defective due to failure to warn. It all goes back to a defective product. It all goes back to whether the product is unreasonably dangerous based on the consumer expectation test. So there's those are the claims in the case. That's the basic concepts of the claim. I mean, it's not negligence we've waived. We're not asking the court to instruct on negligence principles. In terms of any of the other proposed jury instructions that are beyond the pattern jury instructions, we submit that those are correct statements of basic concepts in Nevada law. We recognize that the court's rulings on future motions may affect, the applicability of some of those pre-instructions on basic statements of Nevada law. And we'd ask that the court grant the motion with the caveat that the parties meet and confer on a set of pre-instructions based on the pre-instructions proposed by plaintiff, and any disputes we can raise at that time.
Okay, appreciate it. Thank you so very much. Okay, here's the court's ruling. With regards to document 663, plaintiff's motion limiting number 11 to pre-instruct the jury on standard product liability instruction, the court needs to deny that without prejudice for the following reasons. First off, just as a reminder caveat, this motion limiting was limited to product liability instructions and did not address other, for example, jury instructions, that people need to listen to all the evidence, they have to wait till the end of the evidence, those kind of standards. So focusing purely on the scope of the motion. Here's the reasons why, and this is fact-based and procedural-based as to this case only. Realistically, the challenge here is you have two sets of defendants, one that has made a certain stipulation and another that's not. So it would be confusing, this court would find, with many of these jury instructions to set forth certain standards of liability when you have different, you even have a plaintiff that has two different statuses depending on which defendant's position you're taking. And so I really would find it confusing to the jury to give instructions on liability, because what you really would have to say is, and once again, you're asking me to rule on this first, this is your order, so not after all the other motions that have been done, but at the current status of the case, what you have is, well, the jury would basically have to say, okay, here's some of these instructions, but they may or may not apply to both of the defendants. It really would get very convoluted for this particular case where you are procedurally. That's the first independent reason. The second independent reason is with regards to the statement about doing some meet and confer, and if the court could rule that they can be allowed, the court can't make that as an advisory opinion. The court can't do it. Your meet and confer time period was supposed to be before filing a motion limine. I'm taking into account that you all did do a appropriate meet and confer, and maybe these arguments came up subsequently rather than didn't do a meet and confer beforehand. But if you all had a meet and confer request as to allowing certain things, that would have needed to have been done pre-motion, straight out of the EDCR. And so those would be two independent bases why the court needs to deny it. While not a willing reasoning for the court to deny it, but the court also does remember that I was asked a while ago by Mr. Odou about whether or not this court was going to require a certain version of the standard instructions. And I think there was a statement made about how sometimes it's difficult to find certain versions of said jury instructions. I believe this court said, and I'm paraphrasing myself, is in essence I said I'm going to leave it to the parties to see if you all come to an agreement and whether or not it's going to be one particular set or different sets, that I'm going to look at these as instructions by instructions and evaluate at that time. So while not a ruling for your denial, the court tries to be consistent with, making a representation that I don't see a reason that I would have to change said representation not been presented. Now, if there was some good cause, then of course the court always reserves its right? The rules say I can, and I do. But I don't see it in this case. Like I said, that's not a basis for denial, but I just give you that heads up that I am aware of that aspect as well. Okay, so that's the court's ruling with regards to motion limine number 11. It is so ordered. Moving on to document 622, which is motion limine number 14 by Real Water to preclude the rev check testimony as stated in document 896 with Real Water's notice of non-opposition, so you can appreciate the court's inclination is to grant it pursuant to EDCR 2.20. Counsel for Real Water It's your motion, so go ahead.
Your Honor, nothing to add on the court's inclination. Certainly, if counsel is going to seek permission to file a late opposition, we can address that.
Counsel for Terrible Herbst.
No opposition, Your Honor.
Okay. Well, that was an easy one. There being no opposition, so granted pursuant to EDCR 2.20. Moving on, document 620, Real Waters Motion Limine number 12, to preclude any arguments related to comparative negligence of Real Water. I have a limited opposition by plaintiff, document 797, and a reply, document 913. It appears the limited opposition focuses on, well, I'll read from it. Plaintiffs file this opposition abundance of caution to extend its seeks to prevent plaintiffs from offering evidence of Real Water's manufacturing processes and operations relating to plaintiffs' claim for punitive liability or to prove causation as to Miriam Brody. So that seems to be the scope of the limited opposition. Counsel for movement, go ahead, please.
Good morning. Eric Freeman on behalf of Real Water. Yes, you're correct that there was that only limited opposition. And plaintiffs agree that comparative negligent arguments are improper in strict product liability cases. They filed that limited opposition because there was concern that somehow that motion would try to restrict plaintiffs' ability to put on their case. That was not the intent of the motion. Our reply clarified that position, that it was only directed at co-defendants, I guess now co-defendant, and that comparative negligence is barred as a defense to strict liability cases. The motion is not intended to restrict plaintiffs whatsoever. The intent was to preclude arguments that against Real Water of bad acts, to try to smear Real Water in an attempt to shift responsibility or to get the jury to try to apportion strict liability, which is a violation of Nevada law. Arguments regarding Real Water's operations or alleged bad acts are irrelevant. It's impermissible to attempt to shift responsibility in a strict product liability case. The only intent of that would be to try to confuse or mislead a jury. And I think now that we've clarified the intent of the motion, I think it should be granted.
Okay. Thank you. Counsel for plaintiffs, are you all on the same page?
Yes, Your Honor, with the clarification.
Let me let you get near a microphone. I shouldn't have asked you that question until you were closer to the microphone. My apologies. Go ahead, please.
Your Honor, with the clarification that the motion is not directed at plaintiffs or anything in plaintiff's case, there's no opposition.
Okay. Is it correct that plaintiffs do not intend to present any argument of comparative negligence?
Yes.
Are you all creating some new law that I'm not aware of yet?
No, Your Honor. We do not intend to present any argument related to this motion. We just wanted to clarify that it doesn't apply to plaintiffs. Real Water's counsel has clarified that, so plaintiffs have no opposition to the motion.
Okay. So then here's where the court is inclined to go, and let's just make sure everyone's on the same thing for your phrasing. The court's inclined to grant motion limiting number 12 with regards to plaintiffs taking into account the clarification as to what the scope of the motion is. The court then is also inclined to grant the motion pursuant to EDCR 2.20 with regards to Terrible Herbst because they did not file any opposition. Now, I'm realizing that the way I'm saying that, I'm not in any way changing any law, but it realistically is how you all kind of have procedurally done that. Does that meet the needs of movement? I need a verbal yes or no.
Oh, yes. I'm sorry.
No worries. Does that meet the needs of plaintiffs?
Yes, Your Honor.
Does that meet the needs of Terrible Herbst?
Yes, Your Honor.
Appreciate it. It is so ordered. Okay, so now let's go to document 665. Terrible Herbst motion limiting number 4 to exclude documents and records from Wren action not disclosed in Hunwardsen case and evidence of Chris Wren, his med records, and alleged injuries. Plaintiff's opposition there to document 850. Real Water's joinder should have been document 716. And Terrible Herbst's reply, document 918. So the court's going to have two questions. I might as well tell you all what they are going to be. First off is, since I've already ruled on a particular motion, now that was different because that was a pre-admission, not an exclusion. But obviously, the court's got to take that into account. And here's what else the court needs to get a clarification for how this motion was a little bit broad, okay? From prior statements by counsel and what has been represented to this court, that there is a special master confirmation, okay, that certain, I'm going to use the term documents, records, right, or information from Wren, not regarding his own specific medical condition, but just in general. What I'm talking about is you all have discussed about certain depositions, right, have been taken for multiple case purposes, including the Wren case, right? Notice in that. There's been certain document disclosures that have had multiple designations. I just want a clarification if that is intended to be within the scope of this motion, or if that is a carve-out or something different. Do you understand what I'm saying?
Can I hear the last? Well,
Sure,
can I hear
okay.
the question one more time? I apologize, Your Honor.
Let's focus on where the court's going. This motion appears to have, generally say, two components to it. The first component seems a broad component with regards to the Wren action overall, right, where you reference documents, records, okay? And then you also say evidence, okay? Then it seems to have a second component which deals with Chris Wren specifically, i.e. medical records and alleged injuries. With regards to the first prong of that, if this court is reading the breadth of the motion based on all the pleadings provided to this court, the first part of that could be so broadly read as to preclude, for example, a deposition that might have been noticed in multiple cases, including the Wren case and the, right, which by agreement of the parties or by special master order, as represented to this court, might have allowed such designation. I'm just trying to get a clarification if that's the intention or not, because that was unclear reading through all the pleadings. The second part is a different, distinct, that's specific records, medical records, and alleged injuries. But for the first part, I just need to know the breadth of what you're requesting, please. Okay?
Understood. Thank
I
you.
appreciate it. Thanks so much.
Jan Tomasik for Terrible Herbst. To answer the question, Your Honor, I think I'll start with the second. Evidence of Mr. Wren's alleged injuries and his medical records should be excluded. And I'll stop there unless the court has further questions, and I'll reserve time to, touch on additional points in rebuttal if needed. As to the first question, I think that I understand the court's concern with it being broad. And in terms of the depositions, the testimony, I believe that it can be used for any purpose subject to obviously objections and relevance and prejudicial concerns there. But, however, one of the arguments that plaintiffs make, for example, as well, there was certain exhibits used during the deposition that should be allowed in here, and we don't think that's proper. It invites gamesmanship to only be prolonged along these coordinated cases. That's exactly what the NRCPs seek to avoid. And it shouldn't be the duty of the defendants to guess and speculate which documents were used as an exhibit to a deposition and which ones are going to be used in one of the particular actions. And that's exactly what has happened here. And that was made clear, by the exchange in court on Wednesday. And with that, I'll reserve time on rebuttal.
Sure. Counsel for Real Water, you did a joinder. Go ahead, please.
Your Honor, we filed a non-substantive joinder, but I do want to answer the court's question. It was our reading of the special master orders, let me say two ways. We received the Wren documents because we're in the Wren case. We participated in the Wren deposition because we're in the Wren case, so we received those. So that was not a reason why we were seeking to join this motion to have this excluded. The sole reason we sought to have these documents and Chris Wren's testimony excluded is because he's not a plaintiff in this case. We also agreed with Mr. Kemp yesterday or the day before that there is a special master order that allows a deposition taken in one case to be used in another case. That was to avoid, and it was based on an objection by Real Water, to avoid having our employees deposed multiple times. There must be a showing of good cause to retake a deposition that has already been taken and that's been made available.
Okay, so focusing, since yours was a non-substantive joinder, right?
Right.
When you're using the term documents. I just need a little clarity from you of what you're referencing. Are you referencing, for example, what Counsel for Terrible Herbst just stated about exhibits to a deposition, or is your non-substantive joinder going straight with the med records, alleged injuries, or some third option? I'm not limiting you to those two.
Yeah, we're not arguing that there's a procedural defect in having these documents used in this case. We're arguing it's a substantive defect. It's prejudicial. He's not a plaintiff in this case. That's our only argument as to why they should be excluded, and that was why we joined this motion.
Okay, appreciate it. Thank you for the clarification. The court found it was appropriate, even though it was a non-substantive joinder, to allow to get a clarification based on a question asked by the court. Counsel for plaintiffs, you got an opportunity to respond. Go ahead, please.
I guess addressing the first issue on the disclosure. So just to kind of give the court the background on this, and through the special master, there was a document depository set up with HOLO where, there's more than 20 coordinated cases. Many of the documents and witnesses, we call them.
You all push the mic down if you're going, just so we get everyone plaintiff's courtesy, good, clear record.
No, we're good. Sorry, we're just correcting that. I apologize, Your Honor.
No worries. I just want to make sure, everyone gets a nice, clear record. Fairness, so just push the thing down so we can't cross hear you. Go ahead, counsel. You were starting to say there's a depository for clarification. Everyone is doing it. Yes.
Yes, Your Honor.
Cases. Go ahead, please.
A large number of the witnesses and the documents that were disclosed and produced to the document depository are generally applicable in every case. Those documents were disclosed and produced to HOLO, where it was maintained, where everyone who's a party in the case had access to the document depository. Now, given the number of individual plaintiffs in the separate cases who have not asserted claims against every defendant, given the individual plaintiffs that are involved and the fact that they don't assert claims against every single defendant who's part of the coordinated action, as a way to protect those plaintiffs' individual medical records, HOLO set up special files in the depository for the individual plaintiff medical records, where those files were restricted and required permission to the specific party to have access to those records. So that way only the defendants with respect to that individual plaintiff could access those records, or they couldn't access those private medical records unless they had permission and a good reason to do so. So with respect to Chris Wren, we produced the records. They were disclosed. Chris Wren's injury was alleged in the complaint, his date of injury.
Pull it up now, Your Honor. We're trying to pull up the Hunwardsen complaint to show you the allegations about Chris Wren.
Okay.
Don't wait for us. Just give it a second.
Mr. Godfrey's pulling up the complaint to show that in this particular case, we made allegations specifically relating to Mr. Wren, the time of his injury, the date he was hospitalized, and this, as part of the way that the HOLO was set up, the way that we did our disclosures was we disclosed all the general witnesses and documents in the Wren disclosure, and rather than restate the hundreds, I don't know the exact number, the several different witnesses in every single individual disclosure, we referred back to the Wren to say we adopt those witnesses as though they're being set forth fully here. We did the same thing with the documents. The documents were all produced, they were disclosed, they were available to the parties. The Wren medical records were disclosed and deposited at HOLO way back in July of 2022. They were disclosed in Chris Wren as a witness was disclosed in this case by referencing the general disclosure containing all the witnesses. There was never any objection to this way that we were disclosing it, which was purely just as a convenience. So we're not making every individual case-specific disclosure, upwards of close to 100 pages. And Real Water did the same thing. There was never any objection to this. I know there was a suggestion yesterday that, that may have not been technically the most appropriate way to do that. We've corrected that in this case to list all of them in there, but that is a complete function of a form over substance argument. It is not accurate to say these documents were not disclosed. It's not accurate to say Chris Wren wasn't disclosed. It is not accurate to say that this issue wasn't known. And as
What issue, can we clarify when you use the term the issue?
yes, Your Honor, the issue is with specific.
The complaint section, if you want it now.
So in the complaint, if we can pull it up.
Original complaint or amended complaint or what complaint?
Judge, and I want to point out, we still haven't been able to get the actual Hunwardsen complaint, but these are the same allegations made in each one of the
The court-
complaints. This is Hunwardsen. Oh, this is the Hunwardsen. Okay, go ahead.
Yes, third amended complaint, yes. Okay.
Look at the right section.
This is the third amended complaint, but these same allegations were in there from the
Filed on
first.
blank?
Right there, Your Honor. Top.
Can you give us the date that this complaint was filed?
This allegation was made in the original Hunwardsen complaint.
Actually,
This is the third amendment.
Counsel, are you sure about that last statement in the original complaint?
Yeah, I'm
Yes, Your Honor.
not sure about it, Your Honor.
Okay, because the reason why I'm asking that is I went to document filed on 3/22/2021, document 1.
Your Honor,
If you go to the prior outbreak section, Your Honor, Chris Wren should be the first one there too.
Just a second. Maybe we'll address that in a quick second, but I'm not seeing it now. Quickly skimming through it while listening, might be different, but
Let me.
let's focus on your third amended complaint, then we'll circle back if you have an argument on the
Try to
first.
get the first one.
Yeah. Okay, so let's deal with your third amended complaint. This is a third amended complaint dated blank.
March 7th, 2023.
Okay.
so in the third amended complaint, we lay out all the different clusters of cases in various outbreak time periods. Chris Wren is listed here as a prior incident as part of the 2020 outbreak. That is relevant for a number of reasons, including evidence of prior and subsequent injuries, which under Nevada law, which I don't think is the subject of this motion, is relevant and admissible to product liability claims, defective condition, causation, and if nothing else, notice. So it's relevant for that reason, but Chris Wren specifically is relevant for another reason, which came up, and which is why we originally sought to pre-admit these medical records, because in the expert disclosures by defendants in the Gallagher case, who disclosed the same, Terrible Herbst disclosed the same experts in the Gallagher case, in this case.
Terrible Herbst disclosed the same experts in the Gallagher case as this one?
I phrased that poorly.
I'm
Terrible Herbst disclosed the same experts that were disclosed in the Gallagher case. Terrible.
As UNFI disclosed the experts.
I know.
Yes.
Terrible Herbst stole the UNFI experts.
He stole
Okay, counsel, okay. This court's understanding Terrible Herbst wasn't in the other case. That's the reason why the court asked you to pause because, right, you all have said multiple times, this Terrible Herbst is the first one they're in, so.
Correct,
Okay.
Your Honor. And in the Gallagher case, the experts who have disclosed the same opinions on behalf of Terrible Herbst in this case raised this issue of a distinction between the Henderson plant and the Desert Inn plant. And the theory was, there wasn't any problems at all with the water until Real Water moved to Henderson, and that's somehow, they don't have any theory that's substantiated or supported by any evidence, but something supposedly happened when they moved to Henderson, which the Henderson plant was bad, Desert Inn plant was great. So as part of that, and based on the evidence, we recognize that Chris Wren, who was a probable case as determined by the Southern Nevada Health District, as defined by the Southern Nevada Health District, his water, he was hospitalized with his liver failure before Henderson produced any water. So his injury, his date of hospitalization, the fact that he was determined to be a probable case by the Southern Nevada Health District is conclusive proof that this confusing, misleading suggestion that the problem happened at Henderson somehow, and the water made at the prior facility at Desert Inn was pristine and fine. So this evidence to show that Chris Wren drank water manufactured at the Desert Inn facility before Henderson was ever even operational or in existence, and was hospitalized at this time, is highly relevant evidence. It's also relevant for another reason, because Chris Wren, his date of hospitalization is the basis for the Southern Nevada Health District's definition. They set their definition based on the earliest liver failure injury, the earliest probable case with Real Water out of the 5 families of the children who prompted the investigation. That is Chris Wren. His records showing his hospitalization date and showing that he was a probable liver failure case determined by the Southern Nevada Health District, it shows the basis for their definition. And that is important because I think, we've seen Terrible Herbst has tried to muddy up that to suggest that the Southern Nevada Health District determined that there were no probable cases prior to August 1st, 2020, when that's not what they did. They looked at the 5 cases based on the information they had and set the date based on what they had.
Counsel, as by agreement, parties right, 10 minutes each, be given.
I will sum up right now, Your Honor.
Thank you.
I will just add one thing in terms of the disclosure. The Southern Nevada Health District records, which include these records that they seek to exclude, were produced by the Southern Nevada Health District in October. They were immediately produced to all parties in the case when they were received. So that was another time that they received these records. So to say that we are somehow ambushing them with these records is not accurate. And in terms of the relevance arguments,
Counsel, in fairness, come on, it's been going on for over 20 plus minutes, double the time, right? You all each were given the same opportunities.
we'd ask that this request to exclude these records be denied, that you've already denied that they're being pre-admitted. We ask that the court let the facts and evidence come out, and if the foundation is proper, that they be admitted, or at least allow us to move to admit them and not exclude them on a motion to eliminate. Thank you.
Appreciate it. Thank you.
Judge, can I correct the record? I said it was the first amended complaint. It's actually the second amended complaint that was filed on August 29th, 2022. And that has the rent allegations, and that's it on the screen.
No worries. That's what, yeah, the three. Okay, so court finds it's perfectly appropriate to correct the record when there was an inadvertent error with regards to whether it was the original complaint or the second amended. Okay, thank you.
Jan
Okay.
Tomasik for Terrible Herbst. Judge, if you look past the discovery abuses, the documents aren't relevant. Christopher Wren only drank HOD product, and Real Water is stipulating to liability for all HOD plaintiffs. So even if you accept the discovery abuses, the gamesmanship, the so-called notice, doesn't work because the records are not relevant because it's a different manufacturing line from the retail product, which would be at issue for Terrible Herbst. That was said on Wednesday as well. Okay, now going back to the discovery issues that, make necessary for every single defendant in every single coordinated case to guess and speculate, the documents that they're trying to introduce at trial were not specifically disclosed in Hunwardsen. Done deal. They have not shown...
Counsel, in light of the fact that they reference, right, the second amended complaint and the third amended complaint, is that a time period limitation argument that you're saying? You're saying they never were disclosed.
The documents that they seek to introduce were not disclosed specifically in the Hunwardsen case under their NRCP 16.1 disclosures, which would require such.
So here's, you understand where I'm going to need to go on this one, right? Do you remember the court asking you all yesterday to please get me, right, the special master's order that was applicable? Do you remember someone was looking for it and somebody thought they had it handy, easier? I have not been provided it. It seems to me that you all are referencing something that you've not given the court the benefit of actually seeing. So, once again, how are you asking the court to make a ruling on something that, A, was never in the pleadings, B, even tried to give you all an opportunity yesterday and asked for it. Nobody chose to give it to me. We're now in New Day, still don't have it. So, it's kind of challenging on how you're asking this court, to say something does or does not exist when nobody will even give me the very document which one side says it does allow and one side says it doesn't allow. So, John, this was your motion, so I have to ask you, right? Because you would have had to have provided something if you're saying that that's a basis.
Your
right?
Honor, may I, as to the search for that, we did look yesterday for the special master order that would allow the plaintiffs to generally disclose Wren in that single paragraph or allow depositions specifically noticed in one case to be used in another, and we have not found that yet. No, I'm not saying it doesn't exist, but we're happy to submit the orders we have found to search for that information. I can also tell Your Honor that we found a stipulation between one of the meter defendants and the plaintiffs in another case that a deposition could be used for all purposes, which suggests that there needs to be some separate agreement. But like I said, I haven't found the order yet and we'll continue looking.
Is there an order that covers this? I mean, I've heard I'm stopping you for a quick second because it's not a quick second, but you understand why I'm stopping, is I've had representations as to something, and realistically I said I'd have to review it, right, before this court's going to make any decisions based on, well, I appreciate officers of the court providing generalized information, but since it was difference of opinions of what said order said, I needed to see it so I could read it for myself. If you all had agreed exactly what it said, it would be a different issue. So is there an order? And there's a distinction between the rules in generalized coordinated discovery versus a specific representation. Depositions are different than generalized witnesses in coordinated discovery, right?
I don't understand why we're focused on deposition. Mr. Wren's deposition has not been taken yet. Has not even been taken. Okay.
Well, that would have been a helpful point for somebody to say that that's not part of this motion. I mean, you have to realize that's why I partly said it was broad, right?
But I think that highlights the issue, Judge, is that it's a subsequent action. There's still discovery pending. Christopher Wren hasn't been deposed.
Did
Okay.
you attempt to take his deposition in Hunwardsen?
No, because he was not listed as a witness on the 16.1. And so it's not our duty to guess and speculate
So
as to...
okay, once again, here I've got a difference, right? I've been told there's the standards of coordinated discovery and a case management order, right? I'm re-highlighting the reason why I usually spend a lot of time on CMOs to, right, or get this part, but okay. And I'm not the coordinating judge, so I'm not the one who knows the scope of the coordination. I only know what I can read and what's been filed in the Hunwardsen case, right? So, circling back, are you contending that you had no notice of Christopher Wren even after he showed up? Issue? Or I'm trying to get the sense of what you are actually articulating from the disclosure concept, right? Because, and that ties into really the reason why the court said it was so broad. I need to know actually what documents you're talking about.
Well,
and it would have been nice if somebody said there wasn't a depot, so I wouldn't have been asking about depots, right, that don't even exist for this particular person. So obviously, no one's going to be bringing in a depot that does not exist. Is that a correct statement? Anyone? Okay. Right? I mean, that's the easy one, right? No depots that don't exist. With regards to Christopher Wren, do not use that any broader in any case, any other case that's currently before me, or any other aspect, but okay. And I realize the reason why I'm saying that caveat is because I realize there's an issue with Randolph that I'm not addressing in that last statement. I'm addressing only a Christopher Wren depot. So, now let's walk through. Are you contending that the Southern Nevada Health District document, right, that was referenced, okay? Are you contending that doesn't come in because it lists Christopher Wren as one of the individuals in the probable group?
Yes. And here's
you
why.
have to be clearly saying that in your motion, right? So that this court, I mean, can you please point me to where in your motion you actually articulate that document, please? Missed it, feel free to let me know. But the Southern Nevada Health District document you all have relied on for a variety of different things already in other motions before this court. So you can appreciate the court does not want to give inconsistent ruling, tries never to give inconsistent ruling. I'm not perfect, but, I try my best not to give inconsistent ruling. So Is there a specific reference you're saying to the Southern Nevada Health District document? Because that's got a disclosed witness, right?
So
There's depositions of a 30B6, right? And that document was discussed at the 30B6
Sure.
deposition, right? There's been lots of references, right? Dang is one of the authors of it. So are you, by this motion, now asking that it be precluded?
Your Honor, if I may.
Sure,
So
go ahead.
in our motion on page 12, it does say on the last sentence, just above the conclusion sentence, any evidence and argument regarding Wren's alleged injuries and any introduction of his medical records and SNHD records should be precluded at trial. So to the extent that the SNHD records pertain to Wren, they should be excluded. And here's why, Judge. It falls after in time from Hunwardsen. And the reason for which plaintiffs are trying to introduce those records is misleading. First of all, it's not the same manufacturing line. So it's irrelevant to the claims and defenses against Terrible Herbst, and it's prejudicial. And
I
here,
understand that's your hill you wish to stand on. This court was focusing, right, on the Southern Nevada Health District report. Are you saying that is specifically referenced in your motion limiting?
Your Honor, I don't see that in my motion.
And you can appreciate why the court would ask that question, right?
Yes.
It's been subject of a lot of discussions. If you had mentioned it specifically, you can appreciate the opposition this court may have seen from plaintiffs, right? Might have
I
highlighted that
yeah.
same one because isn't it kind of a document that has, from everyone's viewpoint, a large presence, whether you all view, that's not any opinion on to weight or anything like that, but is one that's been discussed a lot. Okay.
But Judge, if I may, really briefly, going back to relevance, HOD versus retail product, and the reason for which they are trying to introduce SNHD records as they pertain to Christopher Wren is misleading. Okay, first of all, they state that this is the first probable case to identify, but the medical record that precedes his admission to the hospital, which would put their whole theory into effect, is because he presented to the hospital after eating chicken salad. He says those words. That's what he attributes his presentation of symptoms to, okay? And so the plaintiffs have also said that...
Going back to Wilson and the bologna sandwich versus the salmonella at the Pink Pony?
Okay.
Okay. The case you cited yesterday from Circus, the restaurant was the Pink Pony at the Circus,
Yeah.
where the alleged salmonella occurred, not where the bologna sandwich was eaten.
Judge, if I may, the alleged injuries and the medical records of Chris Wren must be excluded.
Okay, I appreciate it. Thank you. I am going to, even though this is taking more than 10 minutes, I think in fairness, because the court asked the question about the Southern Nevada Health District, it's now being saying that's part of the motion, not stated. I need to give plaintiff a few minutes. I need to give Real Water a few moments because I need to have an understanding each of their position as well on that limited issue, if anybody wants a few moments on that. Real Water, do you want a few moments? Are you also seeking to preclude Southern Nevada Health District report in your joinder to this motion?
Not in this motion, no, Your Honor.
I'm focusing just on this motion by motion. Counsel for plaintiff, did you need a true minute or two to respond or not with regards to the Southern Nevada Health District question? If you don't, then I'm going to make a ruling because everyone's had an opportunity to be heard. If you do, you're entitled to a moment.
Briefly, Your Honor. The fact that it wasn't included in the motion is it's telling that they're seeking to exclude a broad scope of documents and evidence on an in limine order that they haven't identified. Chris Wren's injury was alleged in the complaint for this reason, to show he was injured in August. He consumed water. He's a probable case determined by the Southern Nevada Health District. He consumed water from the Desert Inn facility. They want to exclude that evidence and then go argue and present evidence to the jury that all the probable cases were at the Henderson facility. It's just completely improper to try to exclude relevant evidence and then try to take advantage of that evidence to falsely characterize the findings of the Southern Nevada Health District. So again, Your Honor, we'd ask that the motion be denied and we allow the evidence to be put forth at trial. And if there's an issue with specific documents, it can be raised at that time.
It's your motion, so you do get last word if you want a minute or two to respond. If you don't, that's fine as well.
We'll submit on what we've set forth on the record, Your Honor. Thank you.
Okay, appreciate it. So document 665, Terrible Herbst motion eliminating number 4 to exclude documents and records from Wren action not disclosed in Hunwardsen case and evidence of Chris Wren, his medical records and alleged injuries, and the joinder thereto. Granted in very small part and denied in all other respects. The granted in very small part is as follows with the carve-out. With regards to the actual medical records, such as if there's a liver scan picture, if there is something that goes to the details of what actually was the full breadth and depth, currently those are precluded with 2 carve-outs. The carve-out number 1 is that if it's an opening the door issue, then it needs to be brought to the attention of the court outside the presence of the jury. Carve-out number 2, the court is not making any ruling with regards to a generalized reference, and this is going to have to be fleshed out better, and realistically I'm going to speak with you all, and we're going to have to come to some kind of way it's going to get phrased, is the intention of the court's ruling is not to preclude the Southern Nevada Health District report, which, based on however if it comes in, however it comes in, if it does come in preclusion of that report or the fact that there was, quote, a cluster, utilizing words within the report, a first incident, what triggered the report, okay? So those are factual statements. So the court's ruling is not intended to cover that. What the court's ruling really is intending to cover is to litigate the Chris Wren case here in the Hunwardsen case. That's the reason why this court's saying a very narrow granting, okay? That is consistent with applicable law, but court is going to realizes that this one, you're likely going to need some clarity. So I'm going to give you all some time. We can walk through clarity if we have to at the calendar call or early next week, where you all meet and kind of walk through what these specific issues after I've gotten through all the rest of these motions, so we're clear, so you don't have any inconsistent rulings, and you have the clear intent of what is the court's ruling. Realizing that that's where I can go as based on what I currently have. The reason why it's denied in all other respects is, A, it's way too broad, it's way too vague. It doesn't even make it clear which documents are being included, and granting would be inconsistent with the court's ruling on some other motions. So that's why it's denied in all other respects. Does anyone think they need a specific clarification right now with regards to the small, narrow granting, or does it seem to make more sense to you all as well that you talk among counsel so that you can pinpoint the specific issue to this court after we get through all these motions and the court's rulings, and then see what we need to address at that juncture?
Nothing from plaintiffs, Your Honor.
Counsel for Real Water?
Nothing from our water.
Terrible Herbst? further statement?
No, I agree to defer. Thank you.
So, let's move on. And just for a point, Kemp put saying, at approximately 11 a.m. on October 18th, 1980, Wilson's checked into Circus Circus Hotel and ate at Circus Circus's Pink Pony restaurant. That was in.
I missed that, Your Honor.
No worries. I happen to be familiar with the Pink Pony restaurant. I haven't eaten it in like 15, 20 years, so no, it has no impact on any of my rulings. It's just Pink Pony's been around for a long time for those individuals who might have been in Vegas for a long time. So hence I remembered when it said it. It had no relevance other than the fact that you were talking about chicken salad, and so it really brought up bologna sandwiches and Pink Pony. Anyway.
Actually ate there a lot earlier than Your Honor did. Been in existence a long time.
It's been in existence for a long time. It's just really the point. Okay, so that is a non sequitur, does not impact any of the court's rulings, but it just was clarifying why the court happened to mention the Pink Pony. Okay, let's get back to your motions, folks. Okay, going to document 675, Terrible Herbst motion limine number 20 to pre-admit evidence that Nevada Beverage Co. employees drank real water without incident. Plaintiff's opposition, document 864. And Real Water's joinder, document 730. Real Water's joinder was to the motion limine, not to the opposition, so that's document 730. And Terrible Herbst's reply, document 946. Go ahead, counsel, for movement.
Thank you, Judge. Terrible Herbst moves to pre-admit evidence of Nevada Beverage Company employees drinking real water without incident. Now, more specifically on this motion, just to touch on a few high points, Nevada Beverage Co. is referred to as NevBev. That was the only distributor of retail real water product to Terrible Herbst, and therefore it's highly relevant in this case. It's squarely on point with the allegations by Mr. Hunwardsen that this retail product could have contained hydrazine and could have contributed to his injuries. All of that rests on circumstantial evidence to date, and according to Wilson, such evidence is admissible to show that the product was not tainted, and also it is admissible to show notice. The depositions are of the NRCP 30B6 of Nevada Beverage, and it highlights the fact that there was a complete absence of any complaints as it relates to employees that were drinking the same product. It also highlights the fact that there were no customer complaints whatsoever either. at the time contemporaneous to Mr. Hunwardsen's consumption. Thank you, Judge.
Appreciate, thank you. Okay, Real Water, you did a joinder, would you like to
Nothing
be
to add,
here?
Your Honor.
Council Plaintiff, would you like to speak in opposition there too?
I would love to, Your Honor. I was actually looking forward to arguing this for two reasons. And good morning, Your Honor. I don't think I said good morning.
Good morning.
So the two reasons, one, I thought it'd be short, so I thought that was good. The other reason, I thought it'd give me a chance to kind of explain to the court just how ridiculous this motion is. Number one, Your Honor, let's say that that elevator, one of the 6 elevators outside, never had an accident. Not one problem. But unfortunately, I get in there today and it falls to the bottom. And we find out that there was a defective part that caused.
If you're still in the elevator, it's not this department anywhere in this courtroom, is your example?
Just that elevator.
Okay, just making sure, because
Yes,
if it's anywhere in this courtroom, I'm gonna say that, okay, everything was perfectly fine, right? But you're going to the
No, I'm
elevator,
just talking about the
I have no
elevator.
opinion on the elevators. Okay, go ahead.
And
please.
we find that there was a defective part that finally gave way. And it's because the metal was not strong enough. They should have had a different type of metal that kept this part from degrading or degradation, the word you were looking for yesterday.
Thank you, yes, that
No
was.
worries. I wanted to give it to you today. That was the problem. Should there be a parade of people saying, I use that elevator every day for 9 years, like Mr. Marsh is intending to say from Nevada Bev? No, because it doesn't make a difference in terms of that metal. On a strict product liability, it's just the product. Another example, Pinto. There were thousands of Pintos out there. No problems getting people back and forth from their homes to their businesses, their hobbies. But we find out that the location of that gas tank was a problem, was a defect. Should everyone who had a Pinto come into court and say, you know, I drove that Pinto for years, never had a problem? No. The Beatty Court, Your Honor, says the absence of prior legal claims is not even scant proof of product safety. Your Honor, this motion should be denied without much argument. And to grant the motion would be tantamount to inviting hearsay from a Nevada Beverage employee who said he never received a complaint from anyone else who worked for him at Nevada Beverage who may have consumed real water. They don't list all of these workers. So I guess he would just say, well, I spoke to Bobby, I spoke to Tim, I spoke to Eric, and they all told me they drank 10 bottles a day and never had a problem. Your Honor, this motion should be denied summarily. I can't imagine how much error is being invited if this court were to grant this motion. Does the court have any questions? I mean, I could go through all of the points in our opposition, Your Honor, but I think the Beatty-Thomas case is clear on its face. I do believe that any comments from Mr. Marsh, the Nevada Beverage employee, would be an invitation of rank hearsay. And there's been no, in my opinion, no canvassing of all the employees, no medical records, no employment records, nothing that even discusses or describes the employees who were there, how much they drank, how much they didn't drink, did it come from home delivery, did it come from retail bottles, none of that, Your Honor. And do you have any questions, Your Honor?
I do not.
Okay, thank you.
Counsel, you get last word, go ahead, please.
I forgot to say it. I got it right here in my notes.
Your Honor, I don't believe that plaintiff's opposition raises the issue of hearsay, but the issue is that NevBev never received any complaints, and that was testified to by the NRCP 30B6. Now, in other circumstances, I could see where plaintiffs make an argument on this front, but here, Wilson is instructive. It's all of Hunwardsen's claims as to this retail product is circumstantial evidence. And so on that basis, an absence of injuries must be admissible here, and also to show notice. Now, they cite to Beatty, but Beatty even says, which is cited in their opposition, there is a distinct difference between showing the accident and injury history of a product and the legal history of a product. We're not trying to show the legal history of the product. We're trying to show the absence of any complaints. Mr. Parker mentioned 9 years. There was an individual who drank the product for 9 years. It even goes back to 2014. The same customer complaints that plaintiffs showed you, which were uncorroborated, and they went to Real Water, not to Terrible Herbst, it also falls into that issue. The absence of injuries and complaints related to the same product that Hunwardsen makes allegations for is extremely relevant. We would suffer insurmountable prejudice if we are not able to pre-admit these records. Thank you, Judge.
Thank you so much. Okay. Court's ruling is as follows. Document 675, Terrible Herbst motion eliminating number 20 to pre-admit evidence that Nevada Beverage Company employees drank Real Water without incident needs to be denied. And remember, this is a pre-admission. That's the scope of the motion. That's the scope of what the court's ruling on. And realistically, there's several bases on this. One, no one's established how it actually would meet the standards of pre-admission. There's a lot of arguments, right, of prejudice, etc., but it doesn't focus on it meets the standards of pre-admission. Second, realize what you really would be doing. If you're asking the court to grant the pre-admission, you may be leading down that slippery slope that plaintiffs would like to set forth every single plaintiff and every single one of their cases by these counsel and everybody else on all the people who did drink water, right, and come in and say what happened to them. Consistent with the court's prior rulings, consistent with applicable law, this case is limited to the claims and defenses in this case and the plaintiffs in this case. And so if somebody may have drank it, then you're going to get a parade of every single person who did drink it and is going to assert they had any type of injury. That's not the case that needs to be tried to this jury under applicable Nevada law. So the court has to deny. Remember, motion scoped only as pre-admission, so that's the limitation of the court's ruling. The court takes no position on something that's not before it. Thank you so very much. So that was denied. Moving on. Document 611. Real Water's motion eliminating number 3 to preclude any testimony regarding to a reference to other claims, lawsuits, settlements, or judgments. You might have anticipated that my statements were a precursor, knowing what the next motion you all were asking me to do. So you're now wanting to reopen up. Anyway, sorry, counsel, go ahead, please.
Thank you, Honor. Joul Odou on behalf of Real Water. Here are the court's comments. I understand the court's prior ruling and would be happy to answer any questions the court has. If the court has a different inclination, I'd be happy to elaborate further. I think the only other thing I would add on this motion is we also addressed Blaine Jones. And I think the court has made some rulings that affect that part, a piece of it, if you will, because it goes to bias. And so I think that's the only difference that I would bring to the court's attention. And we're certainly not wanting to re-argue that motion. I think that piece of the motion. We understand the court's prior ruling. This motion addresses that prior ruling, so that's already been dealt with. As to the, because it could potentially, the door could be open for bias. We understand that. As to the medical records, currently they would not come in, but if the door is opened, say he claimed he was not injured or some, say he's called, first of all. We don't know that he's even going to be called. But if he's called and there's some impeachment or cross-examination for bias and there's some further opening of the door, then that would take care of Mr. Jones, I believe.
Okay, sorry. I'm mentally walking through some of the rulings. I'm thinking of the pathology reports, the prior rulings of the plaintiffs. Okay, so let me hear from everybody else, then you have last word anyway, okay?
Thank you.
Go ahead.
Judge,
Counsel for plaintiff, go ahead, please.
Well, Judge, these are all a series of motions. They're all the same thing. They're about complaints and injuries.
Right.
Terrible Herbst 3, Real Water 3, 9, 10, Terrible Herbst 10, 11, Real Water 8. We did a joint opposition to all of those.
You did. I will tell you the court was viewing the customer complaints components as different than the claims, lawsuits, settlements, or judgments, right? Because one being argued has one particular purpose, right? Customer complaints. The
Right.
other has some other prongs, and the court's cognizant of what the court just said a few moments ago with regards to the Southern Nevada Health District report and how there needs to be something worked on that. So I do see these differences. If you want to argue them all together, that's the one challenge
That's
is,
fine with me, Your Honor. I don't know if Mr. Odou wants to add more.
I do not.
do you want them all argued together or?
I
one by
think
one?
it's better to keep them separate. I think I have different arguments for the other ones, so that's why I didn't raise those other arguments.
Judge, can I have specifically what he thinks he's addressed in this particular motion? Because he talks about
Plaintiffs.
claims, common exposure plaintiffs. I don't know what he's talking about.
You're talking about individuals who've actually filed lawsuits, or you're talking about anybody who has raised any issue, i.e. the wife of the email of particular disputed statement of what actually the email said, but where are we going with?
That's a fair point, Your Honor. We are, the subject of this motion was plaintiffs in other Kemp Jones lawsuits. There is a one that is in a gray area, and I will clarify that for the court. That's Steve Watkins. Steve Watkins is a plaintiff in another case. His wife sent an email to Real Water saying the doctors had told him not to drink alkaline water. I was going to address that as part of the separate motion in limine, which I think is number 9.
Right.
So I was excluding Steve Watkins' wife, but not Steve Watkins. So I don't know, I can split that baby. So if we need to include Mr. Watkins, I can address it on rebuttal.
Okay, Judge, I think probably better just to give my complete argument on the complaints and the common exposure, because there is a blurring here among certain plaintiffs. Like he's mentioned, Watkins filed the email in 2018, so that's a prior complaint. But in addition, he has filed a lawsuit. Okay, we have a number of people that are in that same category. We have Mr. Jones, that he's alluded to, gets sick. A number of people get sick. Real Water, some of the employees urge them to do a recall. They don't do it for.
I think, so counsel, I think the fair thing to do is,
Yeah,
if the movements don't want to group them, I'm gonna have to take them one by one. If you want to do a combined argument and then I address it, but in fairness, they're the master of their motion. If they want them separated out, then I'm gonna have to do it.
Let's talk about common exposure then, Your Honor.
Sure.
Okay, can I have the second minute complaint back up, Jane? Your Honor, this is the complaint that was filed in the Hunwardsen case. This is the second minute complaint, August 29th, 22. All right, can I have the part about Mr. Haley, Mr. Gallagher, Ms. Gallagher?
And counsel, just the same friendly reminder, need you close to one of the microphones. Does it, okay, if you go over there, just like Mr. Parker did yesterday, if you're close to that one, that's okay. Just need you close to some microphone so you can be heard.
Okay, thank you.
Appreciate it, thank you.
Your Honor, in the complaint, we alleged common exposure for Mr. Hunwardsen. We have Mr. Haley. We have the date of his, this is in the complaint, okay? This was done a year and a half ago, that we gave them notice that we wanted to use these particular injury cases to prove common exposure in the Hunwardsen case. I mean, it's right there. Haley, we have the date, 8/13/19. We have Hunwardsen, his date, 8/23/19, and we have Mr. That's the baby Gallagher's date of 9/20/2019. So we contend that these cases come squarely within Circus versus Wilson. Mr. Haley drank retail bottles from Whole Foods. Gallagher drank from 5-gallon jug, but both the retail bottles and the 5-gallon jugs at this point in time, 2019, came from the Desert Inn facility. And I went through yesterday that they came from the same big gallon.
Concentrate analysis with regards to
right.
electrolysis.
Same thing, Your Honor. So we have 2 cases drinking the exact same product in a very similar time frame, and they both get acute liver failure. So Mr. Odou says, well, can't talk about those cases now, Judge, because they have filed lawsuits. Haley was in the Gallagher case, and Gallagher was in the Gallagher case. The fact that they have filed lawsuits doesn't mean that their common exposure evidence is inadmissible in this case. Okay. Yes, we should not be able to call them plaintiffs. Yes, we shouldn't be able to say they won their lawsuit, but the fact that they drank this water at substantially the same time period and got the exact same injury, that comes in under Wilson versus Circus. And you know, there could be no claim made that they weren't aware of this, because in addition to it being in the complaint, grouped just like that, Your Honor, just like that, we have both Mr. Haley and Camille Gallagher. That's the mother. Orion Gallagher was 8 months old at the time, so he's not a competent witness. But we have both of those on the witness list. And so they're going to come in, unless we can work out stipulated facts, which is probably a better way to do it, cheaper for me anyway. But they're going to come in and they're just going to testify, we drank real water, this is how much we drank, this is what happened to us. That's it. Okay? But that is allowable evidence under Circus versus Wilson. And to preclude that type of evidence basically violates the holding in that case, which is that circumstantial evidence may take the form of illness among others who consume the same suspect food. It was food in that case. Illness among others. These are the others, Haley and Gallagher. Okay, so those two certainly evidence should be allowed for. Now let's move to the probable cases. The probable cases, those are the 25 people that the Southern Nevada Health District investigated. Those are admissible because those are subsequent cases. And again, we're not going to call 25 people to come in. We're not even going to call one of them. Okay.
I'm not sure if I think you had to disconnect inadvertently with your dot cam. Did you mean to have something still up there?
No, I pulled it down.
Okay, no worries. I just want to make sure.
Your Honor, but we should be able to allow to reference all 25 of those outbreak cases, including but not limited to Blaine Jones. Okay, and the reason that that is relevant is this is proof of the causation in this case. All 25 of those people drank real water. All 25 got acute liver failure, which is a very, very rare disease, especially the 5 babies in that case. And Gallagher falls in the same boat. And then the Southern Nevada Health District determined that it was probably caused by real water. I mean, what better evidence of causation could you have? Now, they tried to, their attack on those probable cases is to say, oh, all that water was made in Henderson, none of it was made at Desert Inn, but we know that's not true because of the Chris Wren example. And that's the only reason for the date of Chris Wren's injury being relevant. Okay? It's not really relevant, you know, his acute liver failure versus the other 24, but it's relevant to date. But those cases prove that there was a problem with this water. And remember, real water is still disputing causation on the Brody case. In the Hunwardsen case, Terrible Herbst is disputing causation. If they conceded causation, you know, we wouldn't have to introduce common exposure evidence. But if they're going to contend that there's not causation in this case, we're allowed to present common exposure evidence. And I think it's, you know, so you can't just stand up and say, oh, they're now a plaintiff. So common exposure evidence is somehow trumped by that fact. And that's why it's admissible, Your Honor. But I'm primarily concerned with Haley and Gallagher. The other 25, really, it's already in because the MMWR is in. I don't think there should be a dispute about it. And I don't want to parade in a bunch of. I didn't even want to call Haley and Gallagher if I can get a stiff. But I think the evidence is critical to this common exposure point, Your Honor.
So let's walk through what the motion actually requests versus kind of where this argument is, circling back to some comments that the court made a few moments ago on how we're going to have to work on something to kind of consistent with the claims and defenses in this case, realizing that certain assertions are being made with regards to how certain evidence is going to be necessary in order to try the claims and defenses in this case. So let's walk through the motion. The motion. It does not appear that there's any dispute on settlements. You're not going to try and introduce.
No, of course not, Your Honor. We say that.
I'm sorry, did the court say settlements?
Settlements. Part of your motion asks for not to have lawsuits, settlements, or
There
judgments.
is a dispute on settlements. We settled the Gallagher claim.
I'm sorry.
No, the
Counsel,
settlement.
I'm asking counsel for plaintiff if they're planning on introducing any
Oh,
evidence
about
about settlements.
Okay,
I'm
thank you.
walking through these one by one, so we see what actually the dispute area is, okay?
Thank you, Your Honor.
Counsel for plaintiff, are you planning on introducing anything regarding settlements?
No.
Okay, so not disputed, so I'm gonna hear your final word, but okay, if there's a difference there. And I know there's going to be a carve out, when I'm using the term settlements, the way I see it in the motion is the fact that there was a settlement. I'm not addressing the stipulation in this case. I'm also not addressing the fact that some plaintiffs in other cases may have settled but still may fall within your two categories of what you're calling Haley Gallagher and your other 25, okay? So I'm parsing this out, just the true concept of settlements. I think everyone agrees, it seems, right? Include any testimony, so I have to ask Terrible Herbst. Terrible Herbst, are you planning on including anything regarding settlements?
No, Your Honor.
Okay, because once again, since this motion is for everybody, it doesn't just say plaintiffs, okay? It says any testimony. So no one's trying to do settlements. That one's taken care of. The court need not rule because that's agreed. Nobody's going to be doing that, and that's impermissible, like the ways. Okay, so now let's go to judgments,
No, Your Honor.
okay? No meaning you're not intending to.
Don't intend to.
Okay, thank you. Counsel for Terrible Herbst, are you intending to introduce judgments?
No, Your Honor.
Okay, so now let's go to the lawsuits, and it's going to have a little bit more of a breadth to it, right? Because the court has already allowed, just remember, pretty much it's a single sentence for the purpose of allowing the priors of fact, i.e. the jury, to determine credibility, to see if there's bias consistent with the rule. The court's already ruled that this pure statement that Blaine Jones is a plaintiff is not precluded from coming in
Right.
if appropriately, right, presented for that.
Financial bias.
Yes, that
Just
financial,
like
right.
Nevada average people testify, we can bring out the fact that they're defendants. Financial bias is fair game.
But, okay, so that one, the court's already got a ruling in part on one person, but for other people, are you planning on doing the fact that they have their own lawsuits?
No, Your Honor.
Okay. Terrible Herbst, are you planning on introducing that other individuals have their own lawsuits other than the court's ruling on Blaine Jones?
No, Your Honor.
Okay. So now we're getting to the, and like I said, I'm doing this motion, but so now we're getting to the concept of a broader term. I'm going to have to get some clarification from Real Water on the breadth of the claims. I may have to circle back to you, but from what I'm understanding, counsel, you're saying is you're using the fact that the medical conditions and the notice aspect from your perspective needs to come in with some individuals that are not plaintiffs in this case.
Yeah, claimed injury is the way I read it, not that they're making a claim, a legal claim.
Either with an insurance company, a
Correct.
lawsuit, et cetera. Is
Right,
that-
we're not bringing that in,
Okay,
but we are bringing in their claim of injury.
okay. So let's get a little bit of clarification. Okay, so thank you so very much. I have Terrible Herbst. The reason why I let plaintiff go first is I needed to get some clarity on part of the landscape before Terrible Herbst. You had a chance to give yours in case that made a difference, since Real Water's going to have last word anyway. And I will do these one by one. If you want to say same argument, that's fine, and I'll address it then, but let's do these one by one. So, at least in this motion as phrased, okay? I appreciate it. Mr. Odou can correct me if I'm wrong. So Terrible Herbst, since you did a joinder, you haven't had a chance yet to be heard in the joinder in the first roll, and then Mr. Odou gets final word because it's his motion. So Terrible Herbst, do you wish to be heard in your joinder capacity?
Yes, just briefly, Your Honor. It's our position that no other claims should be tried within this. Claims
So-
meaning,
There we go.
yeah.
What do you mean by
Claims
claims?
meaning
Thanks.
anybody who claims to have been injured, whether they're a plaintiff or not. And there are some individuals, I can think
Okay,
of.
are you saying the nature of their claims, i.e. that they had liver damage, went to a hospital, or are you saying that they made a claim to an insurance company, filed a lawsuit, tried to resolve something informally? I want to make sure we're talking the same claims as a multitude of definitions.
Yes, I understand that word can mean different things. I'm taking it to mean a broader sense than just a claim to an insurance company or a claim to real water. Anybody who claims to have been injured by real water and have suffered a liver injury should not be tried within this case. We've already talked about judgments, so we've eliminated talking about judgments. We've eliminated, I think, talking about lawsuits and settlements. So the next is, what about the folks who just simply have a claim that, whether proven or not, I don't think those are, I think those are irrelevant, prejudicial, and we're going to be trying those cases within this case.
I want to be clear that I'm understanding how you mean the word claim. What I understood counsel for plaintiff saying, when he's saying, can I call one injury and one claim?
Allegation of injury.
Okay. But once again, counsel for plaintiff, what I understand is you're not going to say person X has an allegation of injury and we want to bring out the fact, even though this person hasn't filed a lawsuit. What I understood you were saying is your allegation of injury is, let's take baby Gallagher. The baby Gallagher had liver issues. Is that correct?
That's correct, Your Honor.
Okay, so,
Liver failure.
Yeah.
I don't even think we need to get into the transplant.
okay. So that's the reason why this court's asking the question. Is it taking an action, meaning whether you want to call it a customer complaint, whether you want to call it a claim to some entity, whether you want to call it some unknown claim, right? Versus the fact that they're saying a similarity in illness is the way this court is phrasing it. I'm not saying that that's accurate or inaccurate, whether there is or is not a similarity of illness, but that's why I'm trying to make a distinction on how claims being used twice. So
Sure.
which are you precluding or both?
I am referring to allegations of injury by individuals, whether they make them directly or not, and I'll explain. There is one individual that I can think of who is a plaintiff, okay, but he has testimony, and it's the subject of another motion, limine specifically, but he has testimony, and I think it's encompassed here, about his neighbors who supposedly were injured by real water. So I'm not limiting it to, and they have no lawsuit, they've not made a claim, to my knowledge, or an allegation.
Or something similar to that.
That's
You're talking
correct,
about
John.
persons.
Tom
Pardon?
That's correct, Your Honor, Tom
Yeah.
Pham.
Yeah, okay.
Yeah,
That's
Pham
is that who
and
you're
his- and
referencing?
Ward
Okay.
Korea, Chip, yes, that's who I'm talking about.
Okay.
I didn't want to mention names and confuse you. Okay, that's
I
what
have
I'm
grasped
talking
the names.
about. So those neighbors, to my knowledge, don't have a formal claim. It's Mr. Pham's allegation. So I don't want to limit it to just somebody who's made a claim to an insurance company, somebody who's made, a claim of, or a customer complaint. My point is, we'd go a little broader.
Okay. Real water, it's your motion. Go ahead. Be it last word. You understand, I'm going to ask you the same. How are you defining claims? The fact, the actual injury, or the fact that somebody's doing something about said injury, whether they've actually done it or not, and to the extent that they've done it or not.
Thank you, Your Honor, and I'll start there.
Sure.
Yes, to answer your question, we do believe, and I'll use the Gallagher and Haley plaintiffs as an example.
Sure.
We do believe claims is an allegation, and it should be excluded. So the Nevada Supreme Court addressed this issue in the Guinness case and in the Beatty case. And we cited that in our reply to the combined opposition on page 6, footnote 7. In particular, the relevancy of the evidence is the purpose of what it's going to be offered for. That's the Guinness case, which is quoted by the Beatty case. The issue, Your Honor, that we just heard the plaintiff say was for Myles Hunwardsen that Orion Gallagher and Keith Haley consumed real water and got ill. And they would like to introduce that testimony. By the way, we agreed that they consumed real water and got ill in the other case, not that that's here or there. But we also agreed in this case that Myles Hunwardsen consumed real water, got ill, and was required to have a liver transplant. So they're saying that the purpose of this evidence is being offered to show that he became ill and required a liver transplant, and that his injury is the same or similar to somebody else. That's not a disputed fact in this case.
For real water, though,
For
right?
real water. And because it's not a disputed fact for real water, the Gallagher baby is highly prejudicial. I mean, again, there's nothing more emotional for a mother to come in and describe the injuries to her baby child and do that in front of a jury. It's very difficult on Camille Gallagher. It was very difficult for the jury to hear. And it's very prejudicial in this case because it goes to a fact that's not in dispute that Myles Hunwardsen had a liver transplant. We've disputed the costs of his pain and suffering and the reasonable damages that go with it. And that's really about the length of our dispute with Myles Hunwardsen. So they're trying to say, well, we have to have these 2019 injuries come into evidence because somehow that's going to bolster a claim that's not being challenged. I mean, it's pretty objective evidence he had a liver transplant.
Counsel, can I pause you right there?
Yes.
Because I'm hearing your argument on behalf of Real Water, right? But this court has to rule on behalf of the, I keep on using the term, right, claims and defenses in the case.
And
You have
eventually,
another party who is asserting, right, a variety of different assertions. They've said it more eloquently, but I'm going to just quickly sum it up. But includes a concept that there's been a 2020 date, there's been a type of bottle, as well as a location of bottle. And so you heard Mr. Kemp articulate that if that gets raised, right, that it was solely that there's a distinction between a retail bottle and a jug bottle, then how does, from Real Water's perception, how do they provide their circumstantial evidence to support the fact that it was Real Water versus an independent cause in their citation to Wilson thereof?
I appreciate the court's question, and I'll address it in a couple of different ways. The court's already ruled that Myles Hunwardsen's dabbing of marijuana did not cause his liver, or will not be admitted into evidence to as an alternative cause for his liver injury.
Under Williams Morse College, yeah, go ahead.
So that little piece of, and I'm sorry to pick on Terribles, but that part of their defense has already been ruled it's not going to come into evidence. Then we go to, do they have an expert that's going to provide some other alternate cause for Myles Hunwardsen's liver injury? And that may be addressed in a different motion still. Then we go to the issue the court asked. So that issue, I think, by the time of trial, I think that issue will be resolved. And if necessary, we have to revisit this motion because of other motions that the court makes. We will definitely bring it to the court's attention at calendar call, depending on how the other motions and this motion go. The other question that the court asked was the difference between the 5-gallon line, home delivery, and the retail. Again,
You've heard over the last several days assertions. I'm not taking any position, I'm just saying assertions.
I did, Your Honor. And the defense that was put forth originally by UNFW, and the defense that's been put forth by Terribles is, oh, well, the 5-gallon line was a problem, and none of the problems go to the retail line. And one of the people that was going to offer that testimony is Alec Revchuk. Well, he's just been excluded. So now we come to who's going to offer testimony as to the differences between the 5-gallon line and the retail line. Plaintiffs alluded to it would be Real Water. No, we're not. We didn't in the other case, and we're not in this case. And then we come to Brody, right? Because that was the other question that was raised. The dispute with Brody is medical causation. Was her medical treatment caused by exposure to hydrazine? That's the issue. That's the causation issue.
Comorbidities concept.
Yeah.
Okay.
Yeah, what were her medical injuries caused? So again, we've filed, I know the stipulation came late, I apologize. That was a challenge, and hopefully we'll get it right someday. But
Of all the things, that wasn't exactly the one I was expecting to be challenging, but no worries. It is where it is. Go ahead, please.
And I apologize for that. But the stipulation clearly says that the product was defective as far as Real Water goes. And plaintiffs can drive their truck through that. And the issue for trial for Real Water is reasonable damages as to these plaintiffs. And that comes back, it brings me back to the Guinness case, which is what is the purpose this evidence is being offered for? And there is no proper purpose for Keith Haley or Orion Gallagher through Camille Gallagher to offer testimony because that doesn't go to Myles Hunwardsen's damages. It has nothing to do with his damages. His damages will be awarded hopefully by the jury in a calm and reasonable manner as to his pain and suffering for going through a liver transplant. Court seems like it might have a question there. I'm happy to stop for a moment.
You're correct. I'm not sure it's a you question though, because my question was going to let you finish, because then I'm going to ask Terrible Herbst. Do they concur with what the Waters Council said? Because in essence, I'm hearing what you're saying, but there's not something specifically before me yet.
There is not, Your Honor, and there are other motions in limine that could change the landscape. But I think the ultimate question is, to put it maybe in the affirmative, is what evidence is being offered at trial that the 5-gallon line is different than the retail line? And certainly a lot of people have described it. I just want to make sure that the record is clear as far as Real Water goes. Real Water operated out of Desert Inn. At that time, they were at Desert Inn. There was both a 5-gallon line and a retail bottle, ready-to-drink line, whatever you want to call it. All they did was they simply switched which way the line was operating. It's made from the exact same concentrate. The testimony has been that all of the concentrate was made by Blaine Jones, other than the possible concentrate that was made by, in the early years of the operations, by John Marlowe, and Brent Jones, the owner, acknowledged that he could have made concentrate many, many years ago. So the evidence at trial will be undisputed that Blaine Jones made all the concentrate. The concentrate was, for the most part, manufactured at the Desert Inn facility. It was manufactured up until the date that Real Water split its operations at Desert Inn. Blaine Jones made enough concentrate to account for the move. And so concentrate was made at Desert Inn that was then shipped both to Mesa, Arizona, and shipped to Henderson, Nevada. That concentrate was then used to start the operations of the retail line in Mesa, Arizona, and it was used to start the operations of the 5-gallon line at Desert Inn. So plaintiffs have made an issue out of, when did that happen? We know from Blaine Jones' testimony that he manufactured the concentrate in the first part of 2020, and he was trying to make enough concentrate to account for the move. So when exactly was that concentrate made? We don't know, but we know it was made between early 2020 and the move. One moment, Your Honor. Thank you. Counsel pointed out that I misspoke. It was made in advance of the move of the operations of the 5-gallon line from Desert Inn to Henderson. They shipped concentrate to Henderson. Henderson was local. Henderson was close. At times, they even shipped concentrate that was made at Desert Inn to Henderson, then to Arizona to be used in the retail line. So we believe, Real Water believes, that all concentrate at issue for plaintiffs that are prior to September of 2020 was likely made at Desert Inn. And certainly one of the other pieces of evidence that could be offered if somebody really wanted to is we can call the landlord as to when the water was turned on at Desert Inn. So that mystery could be resolved if somebody wanted to depose the landlord.
Water turned on in Henderson or Desert Inn?
I keep saying Henderson.
Yeah.
Henderson. So, Your Honor, when the 5-gallon line moved to Henderson, there was no water in the facility.
So, I'm sorry, when you said the water turned on, did you mean in the Henderson facility? Because that would indicate, okay.
Yeah, so the way they manufactured the Real Water in Henderson was they used city water and then they filtered it. As the court could anticipate, it's quite expensive to buy water from anybody, and so they're buying it from the city. The landlord wanted to make sure there was a separate meter installed so that the water that was manufactured in Henderson was paid for, not by the landlord, but by Real Water. So they had to set up a separate meter. So actually the production in Henderson, Nevada was most likely later than September because of the need to have that meter installed, and that meter appears to have been installed in late September. And I'm sorry, I've kind of monopolized the court's time.
No worries, I understand. Okay. Did you have an opportunity to finish anything else you wanted to do in your response? And I don't normally like to have people take breaks in the middle of their argument, but if all parties wanted to, for any reasons that you all needed to discuss something before you finished your last words on this, then the court's going to be okay with it. If you want
Yeah.
to finish your last words on it and then the court makes a ruling, that's fine too. I just,
Happy to take a break and double check my notes and make my last presentation as concise as possible.
does anyone object?
No objection, Your Honor.
Objection, Your Honor.
Okay, then we will see you back at 10 minutes after 11. Thank you so very much.
Thank you. Yes, Your Honor.
Okay, we're back on the record. Same counsel, same parties. Mr. Odou, you were in the middle of your final response.
Thank you, Your Honor. Just to sum up, Joul Odou on behalf of Real Water, just to sum up, we cited in our reply some case law as to why it's critical as to what the evidence is being offered for. We've also cited to some criminal cases which talk about presumption of inadmissibility attaching to evidence of prior bad acts or evidence of prior bad acts that have minimal probative value. Here, again, we believe that these other illnesses, for lack of a better word, have very little, if no probative value as to Myles Hunwardsen in particular, but even as to the others. I haven't commented too much on Miriam Brody, but Miriam Brody alleges injuries from retail line from very early on. My browser just closed, but 2018, so she predates Myles Hunwardsen. So again, I think there will be evidence in this case for Miriam Brody to at least say, yeah, I got sick like Myles Hunwardsen because he's right after her. So we think the testimony of Keith Haley, of Camille Gallagher, of any of the other plaintiffs, and as I said, I'll talk about Steve Watkins in another motion, should not be allowed in this case because it's just too prejudicial and has such a minimal probative value. In fact, we think it has none. Thank you, Edmund.
Okay. So, with regards to document 611, Real Water's motion limiting number 3 to preclude any testimony regarding or reference to other claims, lawsuits, settlements, or judgments, the court rules as follows. The court grants in part as really agreed to by the parties with regards to the fact of a lawsuit with the carve-out of Jones or any other prior court ruling or court ruling that might otherwise happen over the next few days with the pending motions. Includes settlement statements that counsel for plaintiffs say they're not going to bring them in, and neither is counsel for Terrible Herbst, as well as judgment. Counsel for plaintiffs say they're not bringing it in, nor is counsel for of the claim meaning something less than a lawsuit. The fact that somebody has pursued their rights would also be precluded, so regardless if it goes to an insurance company. However, with the other determination of the word claim, meaning the fact that somebody is saying that they have a similar type of injury, at this juncture the court needs to I am going to defer on that. The reason why I need to defer is I really need to see at the time of trial, because what that would come in as potentially, at least as asserted to this court at this juncture, is it would come in response to a defense provided by one of the parties currently in the case, and the court can't at this juncture, while I appreciate the analysis of one of the co-defendants, there isn't a pending motion that sets forth that that is actually the law of the case right now, so I have to treat the way the case is currently. The way the case is currently, based on the defenses raised by each of the parties, I have to see if the concept to which the proposed response, which would potentially include and I'm using claims in the fact of injury, not making a claim to a third party, would be relevant or not in response to what may be asserted as a defense, and at least is currently being presented to this court, defense, argument, proposition, etc., by one of the parties. And so that is the court's ruling with regards to 611. It is so ordered.